Welcome to Canadian Justice. I'm Christine Van Gyn. Well, Justin Trudeau has announced that he met with the Governor General who agreed to prorogue Parliament. This decision is a controversial one because Justin Trudeau is back on his heels politically. He's announced he will be resigning as Liberal leader, and while the House is prorogued, his party will select a new chief. But NDP leader Jagmeet Singh, who until recently supported the government, has vowed that no matter who the new Liberal leader is, he will vote to bring down the government. Many are saying that this means the government has lost the confidence of Parliament and that prorogation is inappropriate, either legally or politically. And some groups have even announced an intention to legally challenge the prorogation. Can that be done, and what are the implications? Here today to discuss this are two experts, Professors Paul Daly and Philippe Lagasse. Paul, let me start with the basics. We're using this word that I think we hear, maybe every 7 to 8 years, prorogation. Maybe you can explain what prorogation is, what it does, and what it means.
Very simple. Prorogation brings a session of Parliament to an end, shuts down all business, all legislative business, all committee business, and when Parliament comes back, it's a new session on a blank slate.
So, Philippe, prorogation obviously is not new. It's used to, as Paul said, break up these sessions of Parliament. And it isn't always controversial. In fact, I think it usually isn't controversial. But some people see this case as controversial, either legally or politically. And I explained in that opening why people are taking issue with Justin Trudeau's advice to prorogue this time. Do you have anything to add to why what's making it so controversial this time?
Well, I think the underlying issue here is, as you mentioned, that the opposition parties have indicated that they intend to withdraw confidence. The problem is they said something similar in 2008 when Prime Minister Harper prorogued Parliament in the most controversial case that we have, and then when the Commons resumed, they didn't vote no confidence. So it's one thing to be able to come out and say things publicly as opposition parties, but when you're the Governor General and you have to make these kinds of decisions, you can only base yourself on how the House has acted up until that point. And so in this case, it's probably not ideal for a number of reasons we can probably discuss, but I think it is constitutionally above board.
Yeah, Paul, Philippe mentioned that 2008, 2009 prorogation. That I agree. I think that was probably the most controversial recent use of prorogation. Could you tell me, and this was when Stephen Harper was Prime Minister, can you tell me a little bit more about what happened in that situation?
Well, there you'd had a recent general election, a Conservative minority government led by Mr. Harper. The opposition parties formed an ad hoc coalition. They said they were ready to take the reins, that Mr. Harper should hand over the occupancy of 24 Sussex. And Mr. Harper, to forestall a vote of confidence, a vote of no confidence, went to the Governor General to ask her to prorogue Parliament. Lots of debate and discussion at water coolers around the country about whether the Governor General was bound to accept Mr. Harper's advice to prorogue. Ultimately, she did. And as my colleague Philippe says, when Parliament came back, that coalition had dissipated. It had disappeared into the ether, and Mr. Harper continued to govern happily for the rest of that session.
Now, Philippe, we've only got about a minute left. Would you say that was a more controversial use of prorogation than this one, or about the same or less?
I think so, just because in 2008 you had a situation where, as Paul said, you just had a general election, and that's typically that very close window when you can replace a government with another viable government in the House of Commons. That's not the situation here. In our case, it's either prorogation or dissolution.
Yeah, and I think one of the central questions in sort of both of those cases, the Trudeau prorogation and the Harper prorogation, was whether or not the Governor General could have or should have refused the Prime Minister's advice, the advice in both cases to prorogue Parliament. And there's other historic cases about that exact issue, about the Governor General declining advice. And I'm really interested in the question of whether or not the Governor General has that type of discretion, and how we should, as a a country expect that discretion to be exercised. We've got to go to commercial break, but that's sort of what I want to delve into when we come back. Welcome back to Canadian Justice, where we are discussing the prorogation of Parliament. The Governor General accepted Justin Trudeau's advice to the Crown to prorogue Parliament, and Parliament is now on that break. A lot of people think that there is a political issue with this, and some people think that there's a legal issue with it as well. But we've sort of seen issues in the past, Paul, about the Governor General declining advice or being told they should or could decline advice. But what type of discretion does the Governor General actually have? How much power or authority do they have to say, look, this is the advice from the Prime Minister, I'm going to do something different?
One of the wonderful things about our system, Christine, is that experts don't agree on some of the fundamental principles. So, to be honest, if you had 10 scholars in a room, 10 experts, and you ask them what exactly is the discretion the Governor General has, you might get 10 different answers. There are some people who say the Governor General has no discretion at all. I think most people would agree that if the Governor, to the extent the Governor General has any discretion, it should be exercised sparingly and only in the most not necessarily the most outrageous cases, but it needs something egregious to get the Governor General to reject the advice of a Prime Minister who has the support of who has the confidence of the House of Commons.
So, Paul, this case, what do you think? Is this one of those egregious cases where advice should have been declined, or do you think it's more within the spectrum of what how prorogation is more typically used?
Well, let's start with why people might feel upset about why Mr. Trudeau advised the Governor General to prorogue Parliament. I think there is a partisan advantage to the Liberal Party of Canada here. Instead of going straight into a dissolution where they would be weakened, they'd be under pressure. They either have to go with Mr. Trudeau as their leader, he's very unpopular, or they'd have to find a new leader in a hurry. That would be a very undesirable situation for the Liberal Party of Canada. And so proroguing Parliament is in their partisan political interests. I don't think there's any doubt about that they're going to have a better shot at winning the next general election, be it in March or be it later this year, whenever, with a new leader who has time to run a leadership campaign, get lots of visibility, lots of media attention, drum up support around the country, than if they had to go into a campaign with Mr. Trudeau or someone who'd been selected very hastily. That said, there are other reasons, countervailing reasons, that Mr. Trudeau laid out when he came out in front of Rideau Cottage and explained the situation to Canadians. He talked about Parliament being deadlocked. He talked about Parliament not being able to exercise its functions, and he gave, I think, plausible reasons to support a prorogation, plausible reasons why prorogation is a good idea for Canada at this point in time. And we might not agree with them, but he did give plausible non-partisan reasons, even if we can see that there's a partisan advantage to the Liberal Party of Canada in this particular prorogation.
So your conclusion then is that the discretion probably should not have been exercised to decline the advice.
I don't think this was a case where the Governor General could have declined the advice of a Prime Minister who had the confidence of the House of Commons. No.
Philippe, we've got about a minute and a half left. Paul said, you put 10 scholars in a room and you'll get 10 different opinions. I've got two here. What's your take on the Governor General's discretion?
I think we need to realize that discretion is actually exercised in very narrow circumstances. The first of which is when a prime minister has lost the confidence of the House. And in that context, and this is when we've seen vice-regal discretion. Let's look at BC under Christy Clark, her final election. She lost confidence, went to request a dissolution, and that was declined. In almost all other cases, the only situation in which the Governor General would exercise discretion is if there's a clear example of a First Minister having lost confidence, and that opens up that window. That said, it's important to realize the following thing, and this is, I suppose, where people would disagree. First, if a vice-regal refuses prime ministerial advice, then one of two things has to happen. Either the prime minister resigns or they get dismissed. So there's a huge consequence to doing this.
Mhm.
It's okay, I need the confidence convention is not only between the Prime Minister and the Commons, it's also between the Prime Minister and the Crown. If the Crown cannot accept prime ministerial advice, then it's signaling that it's lost confidence in that First Minister. And the other thing to bear in mind is that what the Governor General will always base themselves on the last thing that the Commons did,
Mhm.
not on projections of what might happen.
Right.
So
And
it's a
and we
fairly
know that
narrow
the
field.
last thing that the Commons did was support this government. Jagmeet Singh has said he will not support in the future, but he did less than a month ago. Sorry to interrupt. We do have to go to commercial break now,
All right.
but we'll be right back. Welcome back to Canadian Justice, where we're discussing the prorogation of Parliament and legal challenges that are being contemplated by some groups to challenge that decision to prorogue. And uh, Philippe, one of the things that some of these people have argued is that the Governor General should have declined that advice from the Prime Minister to prorogue Parliament because they say government doesn't have the confidence of the House. I question if we really know that though, because as we were just discussing in the last segment, Jagmeet Singh, he has said that he will vote to bring down the government, whoever the new Liberal leader is. But he did support them until about a month ago. And I have to say, Jagmeet Singh says a lot of things. He changes his mind a lot. There's a deal that could be struck with the new prime minister, whoever the Liberal leadership race selects. So, how do we actually even know that the confidence has been lost? And if it hasn't been lost, is it appropriate for the Governor General to interject herself and say, I'm going to decline the advice?
So, to your point, the only viable information that the Governor General can work on is what happened the last time the House of Commons voted on a confidence measure. And in that circumstance, the NDP voted with the government. So, to your point, Jagmeet Singh can say whatever he wants publicly because it doesn't have any constitutional weight. And he just recently released a letter basically saying we need national unity to rise up in this time of crisis, basically laying the groundwork for supporting a new Liberal leader and a new Liberal agenda based on the forum speech. The NDP has denied that that's what he's doing, but on what basis are we supposed to believe what they say? They can turn on a dime, as we've seen numerous times. And this is the key point. The Governor General can't be expected to read political intentions or what the opposition party is saying outside of the formal confidence process in the House of Commons. Otherwise, we're asking the Vice Regal to get involved in political tea reading and politics that is just not their role.
Yeah, and one of the things that I'm really curious about is, and this is for Paul. These groups are bringing a legal challenge. I'm actually not sure if it's a challenge to the Prime Minister's advice or if it's a challenge to the Governor General's decision. Maybe you can explain if you know the answer to that, because I don't know. But frankly, I'm surprised that advice from the Prime Minister to the Crown is even justiciable. That it's even something that the courts can give an opinion on, given that, as Philippe pointed out, what they're asking for is sort of political tea leaf reading. What's your take, Paul?
Well, prorogation is a prerogative power, and the courts have traditionally been quite reluctant to intervene in exercises of prerogative power. Prorogation is no exception. There is the famous 2019 case out of the United Kingdom Supreme Court, which maybe we'll talk about in a moment. But you are right to instinctively think this is not something that the courts ordinarily get involved in because the decisions being made are discretionary and are based on highly political considerations, and as you've mentioned, even partisan considerations, which really courts should not be involved in adjudicating on. Um, Probably the target of this case in federal court is going to be the advice of the Prime Minister. It's however hard it is to attack the Prime Minister and discretion that they exercise, it's even harder and quite possibly non-justiciable in our system to attack anything the Governor General did. So I would expect the focus would be on the advice the Prime Minister gave, which the Governor General accepted, but not on her decision in and of itself.
Yeah, in the United Kingdom case, which we're going to talk about in the next segment, that case was about the Prime Minister's advice to the Crown, not in the Crown's actions. Philippe,
Exactly.
anything you want to add there? We're going to talk about the UK case next, but in about a minute, what do you think about this issue of whether the court should be wading into this?
Well, what's fascinating about the UK case, and it touches on this, is that in that case, the court didn't even address whether or not the Crown had discretion. They just took it as a given that the Crown acts on prime ministerial advice. They would have gotten themselves in even more of a complicated situation had they started going down into whether or not the Queen's judgment was correct, given that it's her courts. So we can discuss the minutiae of that, but I think overall, I take Paul's point, and I think it's correct. The tendency of Canadian courts has been to be deferential towards the prerogative and towards vice-regal discretion generally. We may be seeing a bit of a change of that, and we can discuss why that is. We've seen some shift in recent years in light of the British case, but I think in this context, I don't see any reason to think that the courts would suddenly find something justiciable here where they haven't in the past.
Okay, we've got to go to commercial break, but when we're back, we're going to talk about that UK case. Welcome back to Canadian Justice, where we're discussing the prorogation of Parliament and the speculation and suggestion by some groups that the advice by the Prime Minister to prorogue can be challenged legally. And now, since that decision to prorogue was announced, I cannot even count the number of people who have emailed me this odd 2019 case from the United Kingdom, the Supreme Court case about Prime Minister Boris Johnson facing a hard Brexit without a negotiated deal, and he prorogued Parliament. And in that case, the advice to the Crown from Johnson was reviewed by a court, and they found that the advice was justiciable. Now, Paul, I'm sure you're facing the same thing I am, like a million people talking about this case to you. What bearing does it have on Canada? I mean, first of all, it's a foreign jurisdiction, but it is a UK case. It's a Westminster system. But the one thing that I noticed is that in the opening lines of this case, the UK court referred to this as a one-off. So how relevant is this actually going to be here?
Well, you put your finger on one of the most important things, which is that this decision of the United Kingdom Supreme Court is not binding on any Canadian court. No Canadian judge is bound to follow this decision. And a Canadian judge could well take the view that what the United Kingdom Supreme Court said there is inconsistent with Canadian legal practice or Canadian political practice. And so, for example, the fact that in Canada in 2008 we had a prorogation, and in 2010, which is often passed over, we had another prorogation. The Vancouver Winter Olympics was the non-partisan justification, but it had the effect of shutting down a politically damaging inquiry into the treatment of detainees in Afghanistan. And now we have this one. But the historical record, I think, is different in Canada. And any account, any legal or political account of the prerogative and the limits on prime ministerial powers to advise the Governor General should take account of that historic practice. So, in my view, straight away, it's not clear to me that you can just take the decision of the UK Supreme Court and transplant it into foreign soil. That said, it's the United Kingdom Supreme Court, as you said. It's a powerful decision. It's well reasoned, well articulated. It says that where prorogation will interfere with Parliament's ability to legislate and Parliament's ability to hold the executive to account, that calls for justification. And that seems like a plausible enough legal analysis. But if it were applied in Canada, I think we would find that Mr. Trudeau's non-partisan justifications would probably satisfy the justification test that the United Kingdom Supreme Court set out in that case.
Philippe, what's your take? What do you think of the applicability of the UK case, if it might be relied on by a Canadian court? And what do you think more broadly about the reasoning in the UK case?
To Paul's point, I suspect it probably wouldn't be applied, but that said, you never know depending on the judge that you're going to fall on and the argumentation being made. I mean, I say this as a simple political scientist, but it is something I've noticed. Personalities do matter quite a bit in these contexts, particularly around the crown. And the other thing I would note is, to Paul's point, in the UK case, there was the issue that there was no justification provided. In this context, I presume there would be multiple justifications provided. As the Prime Minister said, Parliament's not working, and he needs to have a leadership race. So right there. The wider point I would say, what's interesting to me is that the UK case also relied on unwritten principles, and we've been told by our Supreme Court that unwritten principles shouldn't invalidate law. Does that include using unwritten principles to invalidate exercises of the prerogative as a form of law? I would suspect that that would hold, that you shouldn't use unwritten principles except in very extreme cases to invalidate legitimate exercises of authority.
Well, Paul, Philippe, this has been an amazing conversation. It's something that so many people on social media are talking about. And for you to come on and share your expertise about this has been amazing. So I want to thank you both so much. It's a topic we don't usually get to delve into, but I hope a lot of people watch this and gain a really better understanding of what's going on. Thank you so much.
Thank you.
Thank you.
We've heard today about the history of prorogation and the role of the Governor General. Trudeau is deeply unpopular across Canada and indeed unpopular within his own caucus. But is the right response to his politically reckless decision to prorogue Parliament a legal challenge? Or does this challenge empower courts to wade into political territory they ought to stay out of? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.